Rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear ye, hear ye. All persons having business with the Appellate Division will appear, give your attendance, and shall be heard. Be seated.
Good afternoon. Welcome to the Appellate Division, First Department. We have over 6 hours of argument time that has been requested, and I'm going to ask that you keep that in mind while I call the calendar. Please remember that we have your briefs, we have your record, we know the facts of the case, so please ask only for the time that you'll need to make your most important points. First case is People versus Darius Batts. Submitted. Fuentes versus YJL Broadway Hotel. Give you 5, 2, and 5. Thank you. People versus Clarence Dean. I'll give you Did you say 6? I'm sorry, I can't hear you. Okay, thank you. I'll give 8, 2, and 8. Clark versus the Board of Education, Giammarino versus the Board, Manasalco versus the Board, and Salas versus the Board of Education. 4 cases. 10. I'll give you 8, 2, and 8. Thank you. Getz Fitzpatrick versus OTR Media Group. Appellant, would you repeat that? Try to keep your voices up, please. My hearing is supposed to be excellent. That's what my doctor says, but I'm having trouble. What did you say?
Appellant is requesting 10 and 2 for
Okay. Thank you. 5, 2, and 5. Hudson Spring versus P&M Design.
Respondent Hudson Springer. 5 minutes.
Is there anybody else here?
No, just in case the court has any questions.
Okay. I don't see any questions. Do you wish to submit?
That's fine.
You'll submit? Okay, submission, thank you. People versus Janak Girard. I'll give you 6, 2, and 6. Arch Insurance versus Constructimax. 6, 2, and 6. Thank you. MFP 933 Broadway.
For the appellant, Your Honor, we request 5 and 2, please. Respondent 5 minutes.
5, 2, and 5. Martinez versus Kingston 541. I didn't see a cross appeal here. Is there a cross appeal here? I don't see a cross appeal. I'll give you 5, 5 and 1, 5, 1 and 5. Thank you. Salas Alleman versus CC Controlled. Submitted. And NYC Organization versus Campion. I'll give you 6, 2, and 8. Thank you. First case for argument is Fuentes versus YJL Broadway Hotel.
Appellant that way. He was asking where to sit.
Oh, thanks. Okay, but you can go right to the podium because you're going to be first. Okay, if you would note your appearance, and then
Yes.
begin.
May it please the court, Christopher Drake, William Schweitzer and Associates for the appellant plaintiff. Your Honors, the lower court erred in denying the plaintiff's motion for summary judgment as to liability.
So I have a question for you.
Sure.
Let me just get to it. This is a case where there's a falling object upon the person below. Isn't this a classic 240 sub 1 case?
It is, Your
No
Honor.
safety device, and it falls on the person's head.
It is, Your Honor. The testimony is unequivocal. The plaintiff was doing what he was tasked to do, hold the scaffold for the coworker who was stripping above him. There was nothing employed to secure the device, the formwork that was being dropped below.
Do we know whether or not the person who was on the scaffolding touched the thing,
The actual beam that struck the plaintiff,
exactly, and does that matter?
it does not, we don't know, and it does not matter. According to the most recent case cited in the brief Vero and other cases before that, a plaintiff does not need to demonstrate exactly what caused the object to fall. Inherently invoking the protection of the statute is the fact that the plaintiff was in an area where he was exposed to objects that were falling. In this case, an 80-pound beam that was several feet above him and struck him below.
So the plaintiff's expert, Ms. Hopkins, indicated in her affidavit that overhead protection was needed, such as a fully planked scaffold. Was there any rebuttal?
To that end, no. The only opposition to Ms. Hopkins was that her testimony was conclusory or speculative, which it was not. It was based upon the uncontested testimony of the nature of the work. I'll add that the defendants and respondents attempt to argue that they couldn't have planked scaffolding or provided overhead protection, but at the same time say that overhead protection was not feasible because there was too much scaffolding. In any event, feasibility is not a defense to a Labor Law 240 sub 1 violation, and that goes all the way back to Zimmer. The fact is there was no planking or overhead protection, and there was no ropes or slings that could have regulated the fall of the beam and avoided this accident.
And by the way, why was the plaintiff there? Was he there of his own volition?
Of course not, Your Honor. The uncontested testimony of the plaintiff is that his foreman directed him to hold the scaffold because it was unstable, so that his coworker could strip the formwork 4x3s or doka beams with a hammer. So the plaintiff was doing what he was tasked to do, and at the time that he was doing this task, he was injured because he wasn't provided with any safety devices to prevent the accident.
The plaintiff testified that the scaffold lacked a scissors, something akin to a sidebar or a crossbar, I guess, on each side of the scaffold, and that could have prevented it from wobbling. Did anybody testify or provide evidence to the contrary?
Not that I saw in the record, Your Honor, and in any event, whether the scaffold was up to code, if you will, based upon the plaintiff laborer's testimony is really of no moment. The fact is, the plaintiff was holding the scaffold as he was told to do. Whether the plaintiff was qualified to repair the scaffold as the defendants contend, which is really unsupported by any evidence, or not, he was doing what he was told to do, which is hold the scaffold and assist his coworker. And while doing that, again, this is the accident occurred. If there's no further questions, I'll rest on my papers.
Thank you.
Good afternoon, Your Honors. C. Briggs Johnson for the appellant's respondents. I just want to start where plaintiff left off. There is two separate witnesses who testified. One, that plaintiff was never supposed to be anywhere near this scaffold. and two, that he was never qualified to repair these scaffolds.
So on your first point, that he
Yes.
was not supposed to be near the scaffold, that's comparative fault in my mind, right? I mean, if that's the case, comparative fault is not a defense to a 240 subdivision.
It's not a comparative fault defense, it's actually a sole proximate cause defense if he is told not to be at the scaffold. And BMNY, his employer, testified that plaintiff was a laborer, remember. Laborers are not supposed to be anywhere
The
near
labor
the
law
scaffold.
doesn't say that you have to provide protection from falling objects just for people that you authorize to be at a particular location. It provides that you must provide that kind of protection for any item that might fall and hit someone on the head, just like happened here.
Yes, but, Your Honor, I cited about 10 cases, including the Abad case from 2021 from this very court, that says, not only, this goes to point one also, with the impracticality of having overhead protection, and also the impossibility given the circumstances, but also that when a plaintiff is specifically told that he is not supposed to be in a location where he is at, and that he was not even qualified to be there, his actions can be the sole proximate cause of the accident.
So you're I'm sorry.
Go ahead.
You're challenging the plaintiff's testimony that the foreman instructed him to secure the lower portion of the scaffold while his coworker was atop the scaffold?
I'm saying that not only was he not instructed not to be there, not allowed to be there, I'm also saying that his testimony is barely credible. He's saying that he was supposed to go to this scaffold and inspect it. He was there for a full 5 minutes, and he plainly testified, I never inspected it. I never took a look at it, okay?
But I didn't see anything about inspection.
It's in my brief. When I
Yeah,
talk
but
about
where
plaintiff's
is it in the record?
Oh, I'm sorry, Your Honor. Where plaintiff was never supposed to be by the scaffold, 233, 280 to 281, and 283. Plaintiff had never worked on a scaffold previously at the project. Plaintiff was by the scaffold
You
for...
keep on referring to the scaffold, but the issue here is a falling object.
Right, but also that...
So the issue is whether the work at hand, which clearly would cause the forms to come down, because that was the entire purpose of his coworker, was to chisel these forms off of the concrete, correct?
Yes, that's correct.
Okay, so the issue is whether those forms should have been tied off in some way so they would not fall and hurt someone below.
Correct.
That's the issue.
Correct.
Not the scaffold.
Fine, and that's point one and point two of my brief, that when the goal of the work is to demolish and to remove something from a project, there was a question of fact into whether or not that beam required securing for the purposes of the undertaking under 240, whether it was contrary to the...
So you're saying it doesn't matter whether he was walking there or standing, holding, the fact that this thing came down and hit him in the head, he had to... Let me take that back.
Sure.
You're saying that it makes a difference whether he was walking or standing, holding the scaffold.
Yes,
and
I
that
will...
this thing fell and hit him on the
Correct.
head.
I will put...
So it's okay, in other words, for these items to fall down to the ground.
Your Honor, the Abad case from this court...
Is that, I'm just asking you, it's okay under these labor law circumstances for something to fall down with no protection?
If it is the goal of the work and the purpose of the work, if it is contrary to the objective of the work to secure the object that fell under Cricigno, 2nd Department 2020, under Abad, 1st Department 2021, when there was an issue of fact on whether the door being removed and demolished was required to be secured for the purpose of the undertaking, there are cases from this department and the 2nd Department saying when the goal of the work is to throw the beam down or demolish the wall or throw something off the roof.
A wall is very different.
Yes.
Counsel, how does this case differ from Diaz, where the worker was hit by a heavy 4x8 plywood form that fell or was dropped?
Because indeed...
You have to wait till I
I'm sorry, Your Honor, yes.
or was dropped by coworkers stripping plywood forms from the ceiling. Isn't this a very analogous situation?
I would say the Diaz case is similar, but it's distinguishable. And I see my time is up. If you want me to answer your question, plaintiff had been specifically instructed to remove the plywood from the debris that hit him, where his coworkers were removing the forms, okay? In this case, there's a question of fact as to whether he was authorized and whether he was permitted to be in that area. And two, his project overseer acknowledged that the plywood forms were secured by a rope when they were moved, and that necessarily they had to be secured for the purposes of the undertaking. That's how I would distinguish that case. Thank you.
That's interesting. Thank you.
Very brief rebuttal. In the first place, as the court, I think, was noting to counsel's first point in response that he was not supposed to, or told allegedly not supposed to be near the scaffold. First of all of that testimony is based on hearsay or general orders on the job site through the general contractor, and otherwise there's no testimony that the plaintiff was not told to be there or anything other than the plaintiff's testimony that he was directed by the foreman. Furthermore, the Court of Appeals has made very clear that an instruction to not do something is no substitute for the failure to provide a safety device. An instruction is not a safety device. And finally, with respect to counsel's attempt to invoke abad and other case law that suggests that...
Well, you know, I'm thinking about what he was saying. He's saying that he's trying to argue that your client was the sole proximate cause of his injuries, okay? And I'm thinking about that, and I'm thinking, you know, what if he was fortuitously walking by and the thing hit him in the head? I mean, is that then, can you blame him at that point, saying, well, you shouldn't have been walking by at that point because they were doing work, so you got hit in the head, that's your fault? You know?
Well, again, yeah, you judge comparative negligence is not a defense. I mean, if the area were adequately shored up and secured, this accident would not have occurred. Hence the need to have safety devices or planking. I mean, it would be very feasible, even though that's not the standard, to have planking. You know, the idea that the plaintiff is supposed to work and constantly be looking up, and otherwise, if he doesn't, he can't invoke the protections of 240, I think is completely antithetical to the statute. In addition, I just want to add that the suggestion that the case law that applies where it's illogical to secure something that's being demolished does not apply to temporary construction formwork. It applies to structural demolition, walls, ceilings. It doesn't apply to formwork, and as the court correctly pointed out, that is the holding in Diaz. Thank you.
Thank you. Thank you both. People versus Clarence Dean.
Good afternoon, Your Honors. Upni Bahati from Oric, Harrington, and Sutcliffe, along with the Office of the Appellate Defender, representing Mr. Dean, the appellant. Your Honors, I would like to focus on two issues, one being the Miranda violation here, and second, the bite mark, if I have time. Starting with the Miranda violation, the police here violated Mr. Dean's fundamental constitutional right by illegally obtaining his incriminating statements in violation of Miranda. The trial court then erroneously admitted those statements.
Is there a harmless error view to that?
I'm sorry, say that again?
Is harmless error applicable to that?
Yes, Your Honor.
So here we have a case that has probably the strongest circumstantial evidence I've seen. He's on the video, he's running, getting bags, he's doing this, he's doing that. Okay, practically admits to that, with or without, even if there were no statements, that you see that on the video. And then he has this justification of another person coming into the room, which isn't on the video, which is glaringly absent from anything on the video. So even if there were violations with regard to the statement, why isn't that harmless?
Your Honor, it's not, because it's a confession, which is uniquely damaging. What Mr. Dean would have presented as a self-defense claim, we don't know because these statements came in. He might not have presented a self-defense claim because this case is hard to imagine without these incriminating statements. The prosecution used these statements as a central piece of their case, emphasizing them during the opening.
You're saying he wouldn't have had a self-defense claim? Had he not made these statements, he would have just said, I'm not the guy on the video?
We don't know, Your Honors. We don't know what he would have presented. It's his confession put him in the room struggling with the victim, whereas the videos and the other circumstantial evidence, maybe they involved him in this crime somehow. They put him in that place, but the incriminating statements,
All right,
the statements
first,
after.
Tell me how the pre-Miranda discussion between the police officers and the detective and your client prompted him in any way? Would you describe it as an interrogation, and if so, why?
Your Honor, it was an interrogation. He was asked express questions that fell out of the pedigree exception. The only way you're allowed to ask questions, they meaning the police, they're only allowed to ask
What question was asked that was outside of pedigree?
why he was in New York, where he was staying, what
But
was he
how
doing.
is why are you in New York something that is likely to engender a incriminating statement under the circumstances here?
Your Honor, the murder happened at a hotel. Asking where he was and why he's in
People
New
go
York.
to hotels that live in New York City, so that being in a hotel in and of itself is, I don't think is a thing.
Right, but he admitted that he was at Hotel Carter, the scene of the crime, in room 608.
Let's get back, let
That's
me
not in the
step back a little bit.
pre-Miranda, I'm sorry.
Let me get back a little bit to maybe what is pedigree. Now, I mean, we all, you can say name, rank, and serial number. It's a little bit more than that. But, so what is pedigree?
Pedigree information, Your Honor, is admin information. Name, address, birth date, things that don't relate to the case.
So it's your position that a question that says broadly, where were you, or how'd you get here, or to that degree, does not go to basic pedigree, regardless of the circumstances?
Given the circumstances, Your Honor, given the circumstances where we have a murder occurring in a hotel, asking him where he was, where he stayed, where is he going now?
What about his address?
I'm sorry?
What about his address?
His address, I mean, he lives, that in this situation it goes to the pedigree.
So his address in this situation was the hotel?
No, that's where he was staying, and he was asked that. But, Your Honors, even if the express questioning...
No, but let's stay with that for a minute, because he had a Louisiana, I believe, ID, correct?
Sorry.
A Louisiana ID?
Yes.
Was it from Louisiana?
Yes, Your Honor.
So why is it error for a police officer who is now interviewing someone they think might be connected with a crime who has a ID from another state to ask, why are you here?
Why are you here, Your Honor? It went beyond that, and as Detective Atkinson...
But wait, so why are you here is okay?
No, Your Honors, in this situation...
Why not? If you have an out-of-state person who is being questioned about a potential crime in New York State, why is the question, why are you here in New York, in my state? Why are you here? Why is that a problematic non-pedigree question under the circumstances of a non-resident?
Your Honors, I concede that that might be a question that may not elicit incriminating statements. However, there was more than that in this case, and Detective Atkinson and the trial court found that this went beyond pedigree information. There was an admission here, and the trial court noted that in its factual findings. Even then, its legal conclusion that that was only pedigree information was wrong. Even if it's not express questioning, the circumstances, the second test is whether the circumstances that were created were reasonably likely to elicit incriminating statements. That's exactly what happened here. He was tackled by a man who was at least 7 inches taller than him and much bigger. He was put in a car. He was told, this is gonna be your opportunity to speak. It's over. Detectives are gonna want to talk to you. And then he was directly taken into a windowless interrogation room. All of these circumstances create an interrogatory circumstance, a interrogatory situation where it is reasonably likely that he was going to say incriminating statements, as this court's precedent has held.
Mm-hmm. And just what are the Chappelle factors that are, in your opinion, violated here? Because I'm not sure that I agree that why are you here is an appropriate question without Miranda under the circumstances, but why don't you explain what the Chappelle factors are here that may or may not have been violated?
Are you talking about the Pullman factors, Your Honor?
I'm talking about People versus Chappelle or Chappell. The factors, for example, the time differential between Miranda and the, whether the same police personnel are asking the questions?
Yes, Your Honor.
Are any of
So
those?
those are the
violated?
5 factors. It's time differential, whether there's the same police personnel, change in location, circumstances, and whether the defendant indicated any willingness to speak.
Were any of those violated here?
Yes, Your Honor, every single one of them. There was no time differential between the Miranda violation and the time the statements were given, the oral, written, and the videotape. The same police personnel were in the room. The only difference is that the ADA was brought in at the videotapes.
Was there any break in between the pre-Miranda and post-Miranda?
Yes, Your Honor, he was given a break of 1 hour, but as this court has held in Kohler, that's not enough time, and especially where.
So there's something about a Pepsi at around 8 o'clock. Were they interviewing between 8 and 9:20 or 9:15?
Your Honor, I see my time is up. May I finish answering your question?
Yes.
Between 8:10 and 9:20, they were going in and out of the room questioning him. And then after that, a Miranda warning was given. But the detectives were in and out. He was in the same room.
So where was the break?
The break was after that. The break was given between the oral statement and the written statement.
Right, but then the oral statement has already been given, and then the break happens after that.
And
Okay.
the detectives do say that it's a continuous process. They actually admit that.
Thank you.
Thank you, Your Honor.
Ma'am, ma'am,
There's
please.
some water there.
Yes, I think, sorry. I apologize.
Okay.
May it please, I'm sorry. May it please the court, my name is Alice Wiseman. I'm appearing on behalf of the people.
So, Ms. Wiseman, I imagine I would just like to get right to a question I have, which goes to this whole questioning, pedigree, not pedigree, whether there should have been Miranda. Here's a guy who's on video. It's clear to everybody he's on video. Pretty strong case right out of the box. He's in New York from another location, but how is it that asking him a broad question, like why is he here, how is that pedigree? It's not his name, it's not his address, there are basic pedigree, and then we have trained officers who are asking this question that may elicit information. Why not give Miranda then?
Well, first of all, Your Honor, I actually don't think there's any testimony in the record that they did ask the defendant why he was in New York pre-Miranda. In fact, Detective Rodriguez specifically says he didn't ask him that. What I do think, what the judge found was that there was no interrogation before Miranda. And interrogation, as the court knows, is not just an asking of questions. It has to be an asking of questions that are reasonably likely or that a reasonable person would think would be likely to elicit incriminating information.
Well, Detective Atkinson says she wrote, while she didn't necessarily remember that she asked that, but she wrote, and this was pre-Miranda, that he intended to flee New York with money from his brother, that he stayed at the Carter Hotel and then at the New Yorker Hotel and paid cash, that he sold his laptop and all of these other things. She says this. I don't know that she offers the questions that would have elicited that.
That's correct, Your Honor. The one thing in there that could even remotely be perceived as eliciting, most of the questions, the detectives were very clear. They did not ask any questions about the case, about his relations with the victim at all, about what happened in the hotel.
Well, Detective Rodriguez asked him where he came from before coming to New York, which I think is what my colleague was alluding to. Where did he come from before he came to New York?
And we're not saying that that is necessarily relevant as pedigree information, although the way it came out may have been, where do you live? He had, I believe, an Alabama driver's license. Where are you staying in New York? That's pedigree. And the answer...
Those are pedigree, I agree.
The answer, I was at the Hotel Carter, and then I was at the Hotel New Yorker. doesn't even put him, at the hotel Carter at the time of the crime. It's simply, that is a legitimate pedigree question. So even if, the point is, it's not pedigree, strict pedigree questions or nothing, this is incriminating. It's anything reasonably likely to elicit incriminating evidence. And even if, in the course of a conversation, these detectives asked something that elicited a little more information, you can see if you look at the defendant's videotape statement, he's a chatty guy, he's loquacious, and, they may have gone beyond that. Would we like them to have read Miranda warnings and not be here now? Yes, but that doesn't alter the question of whether, and they clearly were not trying to elicit something incriminating, because he was very quick to tell his story about what happened in the hotel as soon as he was asked. So clearly he wasn't asked. And the questioning, they testified there was an hour. They mostly left him alone in the room. They were going in and out. They were filling out the pedigree form. They were going
Was an
out.
hour enough between the oral and the written statement to have purged any taint that would have happened during that whole questioning?
Well, if there had been any taint, which again, obviously we do not agree that there is, what happened between the oral and the written statement, yes, again, you have to look under the circumstances of each case. There are the Pullman factors or the Chappell factors, but it's not a rigid list. Some are going to loom larger in some cases. Here, important factor is there was nothing incriminating. There was no formal interrogation before Miranda. Once he read Miranda or before reading Miranda, then the detective made clear, okay, now we're going to talk about the case. So there's a big difference in the form of interrogation. The pre-Miranda actual questioning was brief, largely pedigree information, didn't elicit anything incriminating. Then between the oral and written statements, he's left alone. I believe all questioning concluded at 10:50 p.m. They left him in the room, they got him some dinner, he ate his dinner, he was left alone, he was taken to the bathroom. Only then at midnight, they asked him if he'll make a written statement. So he's had time to reset, to think about, do I want to do this or not? And
Counsel,
certainly,
would you address the bite mark evidence that was admitted?
certainly. The only bite mark evidence that was admitted here was simply testimony that there was a bite mark. The defense actually made that a very important part of their defense, because there was evidence that DNA swabs from that bite mark, which got a minuscule amount of DNA, didn't have defendant's DNA in it. So they used that to support the claim that somebody else came into the room and did this. That testimony, so regardless, and it's our position, there was no basis to suppress that, and then the court was never even actually asked to suppress that, or the proper court wasn't. But it was clearly harmless. I mean, it had absolutely no emphasis was placed on it in summation or anywhere else.
Counsel, there was no bite mark comparison evidence introduced.
Absolutely none, Your Honor. Unfortunately, they litigated it for some time, and then we decided enough time had been wasted on that. So, we had other ID evidence. So yeah, no bite mark comparison, simply fact of a bite mark. And nothing in that, that was a minuscule part of otherwise overwhelming evidence. There's simply no reasonable possibility, let alone this is a non-constitutional error, no significant probability that that could possibly have affected the jury's verdict.
Could you just speak to the, in the last few minutes, the, oh my goodness, harmless error, please, aspect of these things that you've spoken with?
Your Honor. Well, I think this is, the court has seen the evidence. This, clearly, a circumstantial case can be absolutely overwhelming, and this is one such case. We have the defendant unquestionably staying in this hotel room, proved by records, proved by his presence on the surveillance video. We have him and the complaining witness going upstairs within a couple of minutes of each other under circumstances where it's clear that there's a connection between them. We have the defendant, they go upstairs at 6 in the morning, about an hour later, defendant comes back down, he's changed his shirt, he's looking perfectly cool, calm, and collected, and no pain. He extends his stay for a day, he grabs some towels, he runs down the back stairs and gets some black garbage bags, and a day after he checks out of the room, The shattered and decomposed body of the victim is found wrapped in black garbage bags under the bed, and defendant has,
Was there any evidence of anybody going to the, on the video, is there any evidence of anybody else going into that room during that period of time other than the defendant, the victim, and the person who found the body?
no, Your Honor. In fact, two detectives testified that they spent hours looking at the surveillance video in the lobby and the elevators. They saw no one who matched the description defendant gave. The key card evidence shows that only defendant's key card was used to go in and out of, excuse me, in and out of the room during that period, and then nobody went into the room between, the day he left and when the maid went in.
Thank you.
Excuse me. And I would just add, again, yes, this is a confession, but it's actually an exculpation. It is the defendant, without this, he does not really have a viable defense, given all the circumstantial evidence. So I think this is a case where, yes, you can say, even if the statements, and obviously the pre-Miranda statements were not admitted, but even if the subsequent ones should not have been admitted, that would not have changed the jury's verdict.
Thank you.
Just a quick rebuttal, Your Honors. Counsel stated a couple of things in the record. Questions regarding why he's here, there was more that was asked here. It went beyond that, and that's on page HA 26 to 90 of the record. Detective Atkinson did admit that questions went beyond.
Maybe you want to
background.
address the bite mark.
Yes, Your Honors. The bite mark evidence here, junk science was admitted, and Mr. Dean had to present a defense against that. It was not waived. In fact, defense counsel presented an objection at the eve of trial.
So beyond the explanation that the bite mark was a human bite mark, well, first of all, did you find that objectionable?
Yes, Your Honor. The defense counsel objected to all bite mark evidence in any testimony regarding it.
So you objected to the classification of the bite mark as human as opposed to a dog?
We opposed it. We opposed the identity of a bite mark, an identity of a mark to be a bite mark. That was objected to. So any mark being qualified as a bite mark, that was objected to.
Why would you have been entitled to preclude the condition of a dead body as a part of the res gestae of a case?
Your Honor, because there's no reliable method to establish whether a mark is a bite mark. And we presented several studies in the renewal motion and testimony as to that effect, that this is junk science. And in fact, the Court of Appeals has noted in Williams just recently that this is unreliable evidence. And so Mr. Dean shouldn't have had to defend against that.
And I'd like to get back for a moment to the issue of your client's presence at the Clark Hotel. Am I correct that that would have been revealed anyway, since your client provided a driver's license when he checked into the hotel?
Yes, Your Honor, but the
So that even if a statement had not been taken, even if they did not question him about where were you and what are you doing here, the fact that he had stayed at the Carter Hotel, the place of this murder, would have been revealed in any regard.
Yes, Your Honor, but also on top of that, he revealed that he was fleeing. And on top of that, even if we go outside the express questioning, the conditions that were created made him reveal statements that were incriminating. So it's not just the express questions, it's also the other test about reasonably eliciting incriminating statements. Mr. Dean didn't know what the police knew. So to him, as an objective standard, what the suspect would be.
That's the case for every person brought to a precinct. You never know how much the police know until they start questioning you and tell you.
Right, Your Honors, but under the circumstances, the questions that were asked, they were reasonably likely to elicit incriminating statements.
Okay.
Thank you, Your Honors.
Thank you. Thank you both. Oh, I'm sorry, are you here pro bono? Yes, thank you very much. From which firm? Thank you very much for your service. Please thank the firm as well. Clark Giammarino, Manisalco, and Salas, each individual cases against the Board of Education.
If it may please the court, Jimmy Wagner for the appellants. I would like to start off by saying and establishing right at the beginning what this case is and is not about. This case is not about the COVID-19 vaccine mandate. This case is about a state education law, 3020, tenured teachers' rights to a hearing prior to be removed from the school building or being disciplined or losing her pay. What happened in our...
Just let me ask you to begin. You said, or being disciplined, but this case is not a case about being disciplined in some punitive way. I imagine you're not suggesting that. You are. So, I mean, this is about conditions of employment. That's what the impact award, which really dealt with the vaccines, that's what they were about, conditions of employment. And that was already determined by another court, federal court in the Eastern District of New York, that that's what these vaccine various safeties of the vaccine, that's what they were, that the impact award was conditions of employment.
Just on a technical level, should I wait for Justice Oing to step back, or are we going to continue without?
No, you can continue without. There are 4 of us here.
Okay. First of all, those cases out of the federal court are not related to our instant case. We're talking about the Garland case, and we're talking about the healthcare workers case. The healthcare workers case is related to an order that states all healthcare workers must be vaccinated as a condition of employment. When we talk about the Garland case, we're talking about an order, different order that's not in the record of this case, that states all firemen must be vaccinated as a condition of employment. What is absent from our record is any order that states a tenured teacher must be vaccinated as a condition of employment. Respondents admit that it's not expressly stated. So what we have is an order that is not expressly stated that it must be a condition of employment for a tenured teacher, and where does the authority for this order come from?
So, counsel, we all know that the pandemic did not exist, I imagine in this case, at the time when each of these plaintiffs was hired, right?
That's correct, Your Honor.
So it couldn't possibly have been a condition of employment at the beginning of their employment. Agreed?
Agreed, Your Honor.
Okay, and then we have a pandemic with astounding worldwide consequences, local, national, state, local consequences, and we have a health commissioner who speaks on behalf of New York City and who issues an edict that people have to be vaccinated, and that applies to firefighters because they're in proximity with the public, and that applies to teachers because they're in proximity with children who at that time had no available vaccine. So I don't understand how you're saying that the vaccine mandate is not being challenged per se. On several levels, aren't you in effect challenging the vaccine mandate? Aren't you in effect challenging the authority of the health commissioner to enact a public welfare, public health mandate? And aren't you in effect also challenging the UFT's right as the union for these teachers to negotiate with the Department of Education with respect to a modification of the employment conditions of the conditions of employment? If the answer to any of those is yes, then part 2 comes into play, which is how do your people have standing to go forward here?
You've asked a lot of questions.
A lot of them.
And let's address each of those issues one at a time. First, there is absolutely no reason why the Commissioner of Health's order cannot exist simultaneously and harmoniously with State Education Law 3020. They both can exist. The prior year, the school...
But 3020 pertains to the imposition of formal discipline. I mean, in order to find 3020 applicable, the concept of discipline has to fall into play. And here, there's no misconduct, right? Performance, bad performance, failure to show up for work. That's not, that's...
Judge, that's an inaccurate representation of 3020, and it's an inaccurate representation of the record before this court. 3020 says you cannot discipline a teacher or remove a teacher. It doesn't say discipline and remove, it says discipline or remove. These teachers were removed from a term of teaching. They started the season, they started their term of teaching in September. Come October 1st, they were locked out of the building. They were physically removed from the term. They could not physically perform their jobs because of the actions of the respondents. 3020 is not, I believe that taking away the teacher's pay was discipline. I absolutely unequivocally state that. However, even if you agree with the risible finding that taking away an employee's paycheck isn't discipline, you would still have to come to the finding that this teacher wasn't removed from her term of teaching, which she was, in violation of State Education Law 3020.
So what was the
Can I just ask,
accord-
because you've gone on a little bit, I just want to ask one question. What is your standing here? How do you have standing? It's already been asked.
Wait, so we have standing both on the Article 75 petition and the Article 78 petition. On the Article 75, 7511(2)(1) explicitly states any individual who did not participate in an arbitration award and was adversely affected by that award can bring a petition.
But this is not pursuant to this. This is pursuant to the Taylor Law ultimately and to the Civil Service Law.
This is a tenured teacher. Tenured teachers fall outside of Taylor Law. They are governed by State Education 3020. And the collective bargaining agreement explicitly states in numerous spots that under no circumstance is a tenured teacher surrendering her state education law rights. And those state education law rights are codified in 3020. So even if the UFT went to this arbitration, there's nothing that could come out of that arbitration that could compel or force a tenured teacher to surrender their 3020 rights.
So why don't you talk about 3024(4)A, which says that the procedures set forth in 3020 may be modified by agreements negotiated between the city school district of the City of New York, which in this case is the Department of Education, and any employee organization representing the affected titles. You're saying that the arbitration in itself was a violation.
I'm saying that this court and Judge Gonzalez, you should continue reading that 3020(a)(4) because what it says
Thank you for your instructions.
No, because what it says is there's no removal without just cause. And absent from this record is a just cause finding.
Thank you.
Jesse Townsend for respondents. Your Honors, as I begin, I just want to make sure this panel is aware that both counsel argued a case of almost identical issues yesterday.
Yes, we are aware. Thank you.
Okay, great. In that instance, I'd like to start where Justice Gonzalez and opposing counsel were ending, which was on standing. Case law makes clear that if a represented employee is challenging either an arbitration award at which her union was a member, was a participant and a representative, or if such a member is using Article 78 to challenge an alleged violation of a CBA, in either case, that person doesn't have standing unless they allege and prove a lack of a breach of the duty of fair representation. That's not alleged here. And if that were alleged here, that would mean that the UFT would be a necessary party. To the extent that petitioners dispute that they are members of the UFT, I would just note that in the petition, they do reference contacting their union representative, meaning the UFT. That's, for example, at record site 26 in the Salas record. I'm going to reference the record on appeal in the Salas brief. So the only way to cure that lack of standing would have been to bring in the UFT as a necessary party. Petitioners failed to do so here. The lack of the UFT also is a failure to join that necessary party in another way as well, because the petitioners seek the vacatur of the entire impact award. That is an impact award that was sought by UFT. After all, it was UFT that alleged DOE had failed to negotiate, invoked the jurisdiction of PERP, and then participated in an arbitration that led to that impact award. To vacate it now without the UFT being present would really cause an inequitable result to UFT and its members. I note on reply—
Counsel, moving on to the merits, the petitioners here say that because the vaccine requirement came down after they had tenure, that distinguishes this case from Beck-Nichols and some of the other cases that you rely on. Does the timing of the requirement matter in determining whether or not it's a condition of employment?
The answer is no, Your Honor. Although it is true as a factual matter that Beck-Nichols, Felix, and similar cases did deal with residency policies that were announced prospectively, none of those cases relied on that fact as the reasoning for holding that either 3020, 3020A, or Civil Service Law 75, in the case of Felix, did not apply. In each case, they drew this distinction between discipline or something unrelated to discipline, unrelated to job performance. And here, what's happened, this is in fact an eligibility requirement. It's not related to the individual teacher's performance, conduct, misconduct, competency to teach. It's an eligibility requirement imposed by the health commissioner's order. And in fact, as Justice Gonzalez was noting, it's impossible, obviously in this case, for such a condition to have been applied before an incumbent teacher gained tenure, because COVID-19 was not known to the world until late 2019, early 2020. The rule that petitioners propose would have really a perverse effect in this instance. This mandate was announced by the health commissioner as DOE was preparing to reopen schools to in-person instruction in fall 2021. What petitioners propose is that DOE could not prevent incumbent teachers from instructing students in class, in person, which was what DOE had returned to in fall of 2021, until holding 3020, 3028 hearings. That would have been just a public health nightmare. And I don't think the case law requires that. I'd also note, Your Honor, that in a somewhat analogous circumstance, there was the Monaco versus New York University case that we cited in our respondent's brief. I know Justice Owing's familiar with that case. But in that case, NYU changed its compensation structure, and it imposed that on already tenured teachers. And the issue was that discipline, such that it fell under the faculty handbook's discipline procedures, which required a hearing, or was it not? And here, in that case, this court agreed that it wasn't discipline, and therefore it could be imposed retroactively.
Yeah, because in this case here, it couldn't be, it's not in the traditional sense discipline, because the teachers here that are involved here have actually an ability to cure the problem so that whatever is imposed is gone, right?
That's certainly true, Your Honor. Yes, that was true, Your Honor. The teachers—
I mean, the impact award even said it, that, you know, you can put in for exceptions, and if the exceptions are denied, then there are certain remedies that you can have. If you don't if you don't put in for the exceptions, then that's it.
That's right, Your Honor, and here none of these petitioners did. What the impact award, along with the health commissioner's series of orders, first August 24, 2021, and then eventually September 15th, 2021, allowed teachers to apply for accommodations under applicable law, and those were considered. These petitioners did not do so. Obviously, the petitioners could then also submit evidence that they had received vaccination. These petitioners did not do so. There also then was provided under the impact award some additional options that teachers who did not want to be vaccinated could take to elect out of the process, extended separation options, extended leave without pay options. These petitioners chose to do nothing, and instead to then challenge when they were placed on leave without pay, which is exactly what the impact award said would happen to teachers that did not get vaccinated and submit evidence of vaccination or request an accommodation. by a date certain. And
Look, the way I look at it, we were under a pandemic, right? The children in my mind were not able to get vaccinated, right? So that you had to, at least in my mind, prevent or minimize the exposure of this COVID to the children, right? I mean, that's the bottom line. So that if you weren't vaccinated, don't come to school to give it and potentially pass it along to children.
that is exactly right, Your
I
Honor.
mean, that's a decision that the health department, that the health professionals had to make. I mean, it wasn't done overnight.
No, Your Honor, definitely not. And in fact, obviously, the health commissioner issued an order in August that led to impact bargaining, alleged failure of bargaining, an impact award. It was reissued. This was a considered process, which also goes to how much notice the teachers had. I do want to just note, Justice Renwick, at the beginning, I believe you referenced a case in ED&Y. I believe you're referring to the Broker case, and that is exactly about 30-20 rights before teachers. There's also the Garland case, which was brought by firefighters, but Broker was brought by teachers and addresses this exact issue.
Yes, Broker is the one I was referring to.
So the answer is yes, this is exactly on point. There's also a King's Supreme Court decision, the Ansbro case, which reaches the same conclusion, that with regard to 75, that these tenure rights don't attach when it's not formal discipline. I just also wanted to briefly touch on the absence of UFT. On reply, I know petitioners argue that Kane-Keel, which was a decision issued by the Second Circuit in November 2021, has already vacated the impact award. That's a misstatement of that case. All that case held was that as applied to a small group of teachers, they had additional rights. Beyond what the impact award had already given them, they had some additional rights to pursue religious or medical accommodations. That's not what petitioners seek here. What petitioners seek here is the vacatur of the whole award. To say that that would not impact the UFT and its members, some of whom have taken advantage of enhanced separation, enhanced leave without pay options, there's no way to say that would not impact them. And I'd also note that UFT, I see my—
Yes, you may.
Okay. UFT does dispute that some later aspects of this policy, whether those later aspects are covered by the impact award. They are not here. They have never challenged the imposition of leave without pay as non-disciplinary in nature. With that, I'll rest my briefs. Thank you, Your Honors.
Thank you.
In reference to this impact arbitration award, the impact arbitration award requires anyone who did not take advantage of any portion of that award to waive their rights to a 30-20 hearing. It states it in the impact arbitration award. The emails sent out by respondents state, if you want to take advantage of leave without pay, if you want to take advantage of XYZ, you must sign a waiver of your state education right law, your state education rights to a disciplinary hearing. If, in fact, it wasn't required, why compel and force my teacher to sign a waiver away those rights? Everyone clearly anticipated that tenured teachers, when you're going to put an umbrella against the entire DOE, when you're going to state of an umbrella that we can remove a tenured teacher who's already started a term of teaching without a 30-20 hearing, they would be in violation of the law. They knew they were in such violation of the law, the arbitrator went and redefined the word discipline. He said, no, you're not allowed in the building, you're not going to get paid, you're not allowed to touch a file. However, that's not going to be a disciplinary action for the purposes of this award. I would ask this court to just look at the plain meaning of—
So why didn't the plaintiffs file a breach of fair representation action, proceeding, grievance, claim against the UFT and have them here as a necessary party? I hear what you're saying, but there's a non sequitur there.
There's no relief requested by the petitioners here that the UFT can grant. The UFT cannot give petitioner back her job. The UFT cannot rescind the Department of Health order.
Except that the relief you are requesting will adversely affect other teachers who have opted into these medical accommodations or religious accommodations.
They would actually benefit. They would benefit because the religious accommodations and medical accommodations existed before the impact arbitration award. That What it granted was management. That's right. The religious accommodations exist under New York City human rights law. The medical accommodations exist under New York City human rights law. They didn't need the impact arbitration award to give them rights that they already had. What happened here was management got a way to expedite it. This award permitted management to expedite these requests for medical and religious accommodations. If, in fact, this award is vacated, it can be vacated to my individual clients or can be vacated to every tenured teacher. Everyone would get the benefit of it. The Court of Appeals has unequivocally stated that if an agent fails to continue an appeal in matter of days, in Case versus Monroe Community College, the individual is permitted, especially when the CBA permits it, as it does here, to continue their fight. And that's what my clients have done here.
Thank
Thank
you.
you.
Thank you both. Getz Fitzpatrick versus OTR Medical Group.
Good afternoon, Your Honors. My name is Paul Golden, and I'm representing the appellants here. When someone is facing a potential 30-day jail sentence, this is a very serious matter, and someone is entitled to their due process rights. Now, I'm not claiming that my client has all the due process rights of a basic criminal case, such as he's already going to lose
Counsel, your client has been given a number of opportunities to come up with documents. You've been here before on this case, right?
Not me
And
personally, but
not
yes.
you personally, your client, this case, these parties have been here before on this. So, and in the last instance, it was sent back for sanctions. Sanctions were given. One of them was produce these documents or imprisonment be required. Is there some section you're saying that that doesn't permit for sanctions of imprisonment or for one to be imprisoned when they fail to repeatedly follow a court's directive?
Yes, well, there needed to be evidence that my client failed to comply with the court directive.
There was a hearing here. Wasn't there a hearing?
Yes, there was a hearing, but the
And?
hearing wasn't designed or wasn't set up in a manner that protected my client's rights.
Your client did testify, right?
Yes, he did testify.
And he testified that he lost the documents because of an eviction. He lost the documents because there was a data breach. He lost what was the other one? There was a third one.
There was some ransomware.
There was ransomware. Of
He
course,
also wasn't.
None of which were mentioned the last time your client was here, and I was on that appeal.
Okay.
And conspicuously absent from his inability to produce were any of those excuses.
Understood.
So they fall on deaf ears.
Understood what you're saying, Your Honor. However, if I may, we're talking about apples and oranges.
No, we're
The
not.
last time.
No, we're not. This court issued an order of contempt
Absolutely.
in reversing the court below.
Absolutely.
And said your client was in contempt. So we were not equivocal or unclear or unambiguous in any way. And your client went back to the lower court and attempted to argue it all over again. So why should we not enforce the sanction that the court imposed after so many orders and so much frustration and so much game playing on the part of your client?
The answer is this. The original order indicating that my client should be sanctioned was indicated because he didn't produce any documents at all. He just flouted the entire order and said, I'm not going to respond, period. No response at all.
So you're saying this is different because he provided some documents?
Yes, he provided, but not just provide some documents. He provided all the documents that he has. He explained there is no
Explain to me why it is impossible to get copies of your client's tax returns from the IRS. Explain to me why it's impossible to get duplicate copies of bank statements from a bank. Explain that to me.
First of all, he did provide tax documents. That was indicated in his affidavit. And second of all, he did attach documents indicating that he was trying to communicate with the bank, but he just simply couldn't get certain
How much
records.
time went by here? How much time went by here? How much time has passed where from when these documents were first requested until now? That's not exactly a valid explanation that I've been asking my bank, and I can't get the documents. I can't get these.
I think he got some records from the bank, but not others, because the bank.
So, counsel, didn't the lower court make a credibility finding as to your client, and didn't the court find your client's testimony to be incredible? After all, according to the plaintiff, out of 411 out of the 434 pages that were produced were either blank or non-responsive. I've never heard of a production of blank paper as being satisfactory.
Well, first of all, of that, he didn't say how many were blank and how many were non-responsive, and it's a question of fact and credibility as to whether it was and
that finding was made by the lower court, right?
I understand the court basically said that not everything was produced. What the court did not say was that my client actually had access. It just said that he didn't provide certain documents. And the court said these exist. Well, they may exist. But that doesn't mean my client, who's not running that defunct corporation, still has access to them. And the court never said that he actually has access to them. The court never decided that. But besides that, the hearing was done improperly. The court took the bull by the horns and didn't give my client the chance to testify on his own, and didn't ask for any evidence from the other side. I'll save my time for rebuttal.
Yeah, thank you. While you think about rebuttal, he was represented by counsel at that hearing, correct? You can just think about that and a response to that.
Good afternoon, Your Honor. Scott Simon, Getz Fitzpatrick. We are the respondent here. You asked the question, just addressing this right away. It's been over 3 years, close to 4 years, since the original subpoenas were served on not only the corporation, but also the individual contemnor here. In those 3 years, the contemnor produced 2 or 3 bank statements, 1 tax return. We've asked for years of both. None were ever provided. The appellant says that there was no opportunity to present evidence at this hearing. Appellant did not attempt to present evidence at the hearing. Appellant gave an affidavit that gave 3 incompatible, incredible excuses that maybe my documents were lost when a landlord posted a notice on our office door that said, "You haven't paid your rent," and he claimed that everything in the office was then lost to him, his computer system, his documents, everything else. But then he said there was a ransomware attack that happened preventing him from giving documents, but also there was
Counsel,
a server.
just to interrupt you. Justice Kotler said he had to spend 30 days incarcerated, correct?
Correct.
Is that punitive? In other words, if he purges his contempt on the second day, should he stay the other 28 days?
Your Honor, if this contemnor decides to produce the documents after 3 years, it's Justice Kotler's discretion on how to handle that. We're saying that the record here shows that Justice Kotler did not abuse her discretion in ordering the incarceration.
But in civil contempt, the penalties are made to make the contemnor get out of contempt, correct?
Correct.
So I return to my question. If he produced the documents on the second day, does he get out of jail free card?
I would have no objection to that, Your Honor.
Or if he pays the judgment in full.
Correct, Your Honor. Look, Justice Kotler followed your directive Okay, the remand order said this individual is responsible for causing his company not to comply with discovery for 3 years. Therefore, this individual is in contempt. Lower court, please issue a sanction. The court did. On May 12th, 2021, the lower court entered an order, said, you gets Fitzpatrick, you get your legal fees incurred in chasing this guy for 3 years, and if the contender does not produce documents within X days of the order, he's going to be incarcerated for 30 days. The production before the deadline was completely insufficient. We produced that through Dropbox to the court. The court was able to review and see that 411 out of the 434 pages were blank and were non-responsive. And the court heard this testimony at the hearing, read the affidavit, saw these excuses that were given, discussed them on the record of the hearing with the individual, and found that the excuses were incredible and otherwise unsubstantiated. There were no documents produced with the affidavit. You would think if there were an eviction that the contemnor would have evidence of an eviction proceeding. If there were a server crash, you would see him communicating with his ISP. If there were a ransomware attack, perhaps he would have communicated with the people stealing his data. I don't know. It's not our job. The issue here is that there's no question, and even the appellant doesn't question, that he failed to comply with the court order by producing everything that we requested 3 years prior. When he failed to produce, when he failed to comply, the burden then shifted to the appellant to show that there was a valid excuse. Counsel claims that the valid excuse is he doesn't have the documents, and there must be a good reason for that. But the court heard that reason. The court found it incredible and unsubstantiated.
Thank you.
When someone is facing 30 days in jail, they're entitled to some due process rights. One of them would be...
Wasn't there a hearing?
Yes, there was a hearing, but
And he was represented by counsel at the hearing.
Yes, he was represented by counsel, but that's not the only things that are necessary when we're dealing with a quasi-criminal matter. One of them would be that the party claiming that my client's in contempt has to produce evidence, and they have to produce clear and
Counsel,
convincing evidence.
this is a case that was just articulated how many years it's been, and that out of 400 and how many papers, 411 were blank. The
Not
court
blank,
had,
blank or non-responsive.
or non-responsive.
That's their
The court
opinion.
had
That's their
this-
position.
Well, then there it is. That was there. That was already, that was what prompted the whole hearing. So it was there for you to respond to.
Yes, and my client's response was, I don't have any more documents. And I have to point out, Judge Kotler never said that my client has access to the documents. Someone can't be held in contempt because they failed to do something that is physically impossible to do.
Well, those documents aren't, but wait, well, one second, but those documents are not in the sole custody of your client. I mean, we're talking bank records and IRS returns, correct?
Yes, some of them,
Right, so-
he did produce some IRS.
Well, when you say some, give me a number, 1, 2 years, 3 years? I mean, your counsel over there says you only got 1 year worth of
I believe the brief indicates that it was from 2014 to 2017. I could be corrected on that, but he did produce some tax records on it.
The court had, I'm sorry. Yeah, you finish.
I was going to say some is not, obviously Judge Kotler didn't agree with your client's assessment of what documents he had, so.
But
The court had to assess whether it believed he was making, over here, diligent efforts to comply. I mean, that's part of it. Not just, oh, look, this is what I have, and then nothing. The court has to make that determination and made the determination. And the counsel could have objected or provided other evidence or made whatever arguments.
Can I say one last thing on
Yes,
this
of
one?
course.
The court, Judge Kotler never said in her determination that the other side reached their burden, one, and never
Counsel,
said.
I'm going to stop you right there because they had no burden. This court declared your client was in contempt. I don't understand why you are having trouble understanding that. All that the court had to consider was what was an appropriate sanction. That's it. That's what we remanded the case for. So your continuous arguments about they had some burden to prove contempt is flatly wrong.
All right, well, I disagree with you, but my time is running out. I just want to say.
It's
finally,
run
that-
out, but I'll give you 30 seconds to wrap up.
All right. My position is that there's two different orders here. One is from Your Honor saying he's been sanctioned because he failed to
No,
produce
we
anything.
held he should have been held in contempt.
Definitely. He should be held in contempt because he didn't respond at all. No response, period, period, period. Now he does provide a response and says, this is all I've got. He can't be held in contempt for giving everything he's got.
And the lower court didn't believe him.
No,
That's a
the court did-
credibility finding.
However, the court.
Thank
didn't
you.
say- Thank you.
Thank you both. People versus Janak Girard.
Good afternoon, Allison Haupt on behalf of Janak Girard. Mr. Girard was denied his constitutional and statutory right to be present at a material stage of trial. This error.
So do you find that, over here.
Sorry.
So do you find that then, that his counsel's triggering this question, did that amount to a waiver? Because, you know, the court was more than, the way I read the record, the court was going through the process and discussing, and then defense counsel says, oh, wait a minute, should my client be here? Do you find that problematic?
So what the case law establishes, and it's the cases that I'm referring to are Mehmedi, Aguilar, and Carr, they're all cited in our briefs, that when you have a violation of the right to be present, and specifically a violation of a statute like CPL 260-20.
Right, it's a statutory right, right. It's more flexible. Statutory rights are more flexible in terms of allowing us to look at, you know.
But actually, what the case law says is that when you have a statute that goes to a mode of proceedings, which the Court of Appeals said 260-20 is one such statute, that in that case, what Mehmedi holds is that defense counsel is not in a position to waive for the defendant. It's the defendant.
Well, it's more simple than that. I mean, this whole discussion came about because of the heart issue, right? His medical condition, correct? I mean, it had really nothing to do with anything legal, right? It had to do with all the facts, correct?
Which is why it's a material stage of trial, because what this proceeding is about is whether the scope of a testimony that was allowed in pursuit of a justification.
So your position is counsel could never have waived it, could not have waived it, and if you were to look at it, it's a nullity. Is that your argument?
The person that needed to waive was Mr. Girard, and the evidence makes quite clear on this record that he did not do that. And I would cite to this very court's decision in People versus Douglas, which is virtually indistinguishable, that when you have a proceeding that's going to the scope of testimony in a justification defense, then one, that is a material stage of trial, but two, defense counsel cannot waive. And if you look to the specific facts that
And critically, he testified, your client testified at trial too. He's giving testimony at trial, right? I mean, that's a big...
And he wanted to be able to testify about this, but it was not allowed. This proceeding that was going to what that scope was. And if I can go back to Douglas, in Douglas, defense counsel actually acquiesced to his or her client leaving the courtroom. The court said, you know, maybe he should leave. She says, sorry, he leaves. And this court said that that's not waiver.
Is that another way of saying that a defense attorney can never implicitly waive a client's rights to be at sidebar? In other words, in those instances, we're saying, oh, well, wasn't it implicit? But without some acknowledgement that the defendant actually understands that they have a right to be at sidebar in the first place, which I think is completely absent for this record, there is no way for a defense attorney then to say, I waive my client's right or let my client step outside, because there's nothing to show that the client has already understood.
Exactly.
Would that be correct?
Right, it can't be a knowing and voluntary waiver if Mr. Gerard has no understanding that he has a right to be there. It's clear that there's no conversation between him and the court or him with counsel. So whatever counsel is saying, that's her own opinion. It's not a description of Mr. Gerard's statement of waiving his right. And so this cannot be a knowing and voluntary waiver, and therefore, this is reversible error. And again, I just want to point out, Douglas establishes all of this, the very same type of proceeding, the fact that defense counsel says,
Does it
sure,
matter that in Douglas, the defendant had threats against him the day before the incident? In this case, we're talking about a heart condition, which there's no, as I can see, no offer of proof about what the heart condition was and how it would affect his feelings of needing to self-defend.
And
Does it matter that there's that not the factual predicate exists in Douglas, but I don't see it existing here?
Well, first, I want to make clear that there are two separate issues in Douglas. The one was the question of, should this evidence have been allowed? That's the first point. And then separate and apart was the fact that Mr. Douglas was not allowed to be present at the proceeding. Was that an independent violation? So whether or not this evidence should have ultimately been presented, that's not before this court, and it's largely or entirely irrelevant. The question is, should Mr. Gerard have been present there? And
isn't the fact that in the record, when the judge is questioning defense counsel about exactly how this condition could relate to the case, the attorney says, I don't know what my client is going to say, which only begs the question, then he was absent from the very point at which he might have been able to assist in his own defense.
Exactly, Your Honor. These are factual questions that are specifically within Mr. Gerard's own control. It's his medical condition. It's how that medical condition made him fear. The questions are, did he feel faint? Was he thinking about his medical condition at the time? He is the best source of that information, and defense counsel is saying, as far as I know, as best as I know, I'm not in his shoes. I don't know what he's going to say. So this is the exact type of proceeding that a defendant needs to be at, and that only with a valid waiver from him, which was not present here, that is the only way that he could not be present.
What do you respond to then the concern that there may be, that if the defendant were present, that the testimony he's going to give would be tailored to whatever is discussed at the conference?
Douglas rejects that as a reason to exclude a defendant. It explicitly states that that is not a basis and not a justification to deny somebody their right to be present at this proceeding. So this very court has already established that is not a basis to exclude Mr. Gerard.
And it may be that he could have been excluded after saying, you understand you could be here. Do you want to be here? No, I'm okay. You take it. Then they could continue to talk and he could be gone, but not without making sure that he's perfectly aware that he could be there.
Exactly. Thank you, Your Honor.
Thank you. Did you?
May it please the court, my name is Patricia Curran and I represent the people on this appeal. This defendant waived his presence.
How?
Because his lawyer asked him to step out.
His lawyer asked the judge, Judge, do you think my client should be excused? Where is it, anywhere, that we see that the client has understood that he has a right to be at the sidebar? How does that convey that he has a right to be at the sidebar?
Your Honor, waiver can be, as the Court of Appeals has said in both Flynn and Velasquez, that it can be explicit or implicit. In addition,
implicit is only where the attorney is saying, I've talked with my client and we waive, or there has to be some indication that the client is aware of what has happened already.
The Court of Appeals says otherwise, Your Honor. In People v. Francis, the Court of Appeals said that the court cannot pro forma inquisition in each case on the off chance that the defendant who was adequately represented by counsel may nonetheless not know what he's doing, and that was in the waiver context. So the waiver here meant that he has waived
that
his
in
presence.
Flynn, you quoted Flynn, and in Flynn, there it was the court that advised the defendant that he had a right to be present and welcomed him at the sidebars, let him know before the issue came up that he could come up. He chose not to come up. That is not the case here. At no point in the record, and if I have missed it, please point it to me in the record, where either the judge advised the defendant, by the way, you have a right to be present at this juncture. do you waive that right? Or there's no statement on the record where the defense counsel says, I've spoken with my client and my client waives his right to be present at this proceeding. There is no such statement anywhere in the record that I could find. Am I incorrect about that?
You're correct, Honor, but that's not necessary, because this was a legal argument, and I know Justice Owing...
It's not, okay, it was a legal argument.
Yes, Your Honor.
Based on,
His
the judge,
presence...
multiple facts are discussed here about what happens, about his heart, about the whole thing. It's not merely legal. It went into deeply factual questions that the court asked that has already been indicated that the attorney wasn't able. I'm sorry if I'm boring you. I see you tapping your foot and looking down.
You're not boring me at all, Your Honor. I'm waiting to answer your question.
I just wanted to make sure. I just wanted to make sure. And it also is clear that the court asks a question factually that the attorney is unable to answer. Why is that not factual?
Your Honor, this discussion started when the court asked the defense attorney how the heart condition had relevance to his justification defense.
That may be.
Now,
that may be, but just because we start off with one question doesn't mean the entire conversation stays on that. This was a question that very quickly went to the factual aspects.
Your Honor, all legal arguments have a huge factual component, particularly something involving the subjective point.
Some go far more in detail, and this one did. This was all about the condition of what happens, and why is that relevant to your justification defense.
Your Honor, this still was not a material proceeding. It's still an ancillary proceeding here. And we disagree with
whether he can assert the defense of justification and what he can use factually to support a justification defense is not material?
Your Honor,
that was his defense. Whether it was a good one or not is another issue, but that was his defense.
The Court of Appeals has said that the right to be present doesn't rely exclusively on what the potential contribution could be from the defendant. It's whether his absence impacted his defense. Here,
counsel, there's
his
where I have
heart condition.
Hello.
Yes, I'm sorry, Judge. I can't tell who's talking to me all the time.
I have my mask down.
It's okay.
So my problem here is the lack of information. There's no query of the defendant. We know that. As to his waiver of his right to be present. There's no explanation. But similarly, when the attorney, when counsel is queried about the nature of the heart condition, and the answer is, I really don't know, that for me sends up a whole bunch of red flags. How do you get around the fact that the attorney did not say at that point, and the court did not say at that point, well, you know what? If you don't know the answer to the question, let's bring your person back. Let's bring the defendant back because we don't have enough to go on here.
Your Honor, defense counsel spent something like 40 pages worth of transcript talking about what her belief was in terms of the heart condition, which, by the way, he was not taking medication for either at the time of the stabbing or at the time of trial and was not being treated. So she had the ability to call the defendant back in at any time. The judge never told her that she couldn't. He also never told her she couldn't talk to her client before he continued his testimony. And in addition, she says, I don't know what my client will say. She doesn't mean I don't know the facts of all this. She means when we continue the testimony, I'm not sure exactly how this will come out because I haven't coached him. She uses a different word. But that's what she meant, not that there were more facts that he could contribute.
Thank you.
She wasn't able to answer a lot of questions, so I'm not sure that I agree with that characterization. There were some very specific questions that an attorney prepared for trial should have been able to answer.
Your Honor,
she
goes,
wasn't.
I'm sorry, she goes on and on about what the doctors have told her in terms of this and what the defendant has told her. And by the way, he says he didn't pass out. And the judge doesn't stop her from bringing out the information. He says, Well, let's have him testify and see if he's going to be able to relate the conditions of his heart condition to the justification defense.
Thank you.
Counsel, when the defendant came back in after the second colloquy, was the defendant advised about what happened during that exchange between his attorney and the court and the DA? Or was he just put on the stand and started asking questions?
The latter, Your Honor. He was never advised of anything. He was just put on the stand. And being put on the stand is not the same as being a participant in a proceeding discussing the scope of testimony where the court ruled against that scope being allowed. Your Honors, unless you have other questions for me or other questions about the other points in the case, I'll rest on my briefs.
Thank you.
Thank you.
Arch Insurance versus Constructimax.
Good afternoon, Your Honors. May it please the Court, James Lane is for appellants. I'd first like to focus on the trial court's construction of the settlement agreement and several key flaws that are reversible error. First, the trial court did not consider the complete settlement agreement. It based its interpretation of the contract on a provision, Article 6.6, which purportedly preserved Arch's indemnity rights.
Well,
However,
it seems to me that seems to me that 6.6 is pretty, is clear and unambiguous with regard to Arch preserving its right to seek indemnification against CMAX.
there is no specific reference to the indemnification claims asserted in this action, which is...
But there is specific statement that says surety rights under indemnity agreement are not impaired. That's pretty clear.
That's correct. However, there were 4 separate GIAs, just for convenience, GIAs that were referenced in 6.6, one of which did not pertain to the project at issue or the bond at issue. And if the trial court had viewed and reviewed the 4 separate GIAs referenced in 6.6, it would have been able to harmonize it with the intent recital, which was made an operative provision of the settlement agreement and specifically stated that the intent of the parties was to settle all claims amongst them.
Yeah, but that settlement agreement was between Arch Insurance and Constructimax versus the other guys in terms of, you know, I don't see how you say that. I mean, they were unified in that sense. Arch and your client were on one side versus the other guys. That's the settlement that came down, correct? I mean, if you look at that, when you say that recital means settled all claims, I'm looking at who's on which side of the V. You and Arch were on one side, everybody else was on the other side. So how do you say that Arch waived or at least relinquished their claims against you?
Sure. Earlier in the agreement, the parties are defined. Parties are defined as Arch.
Yeah.
Everyone. And then they're also individually defined,
Yeah.
Arch CMAX. And they're also collectively defined, Arch CMAX together.
Yeah.
So they had the ability when drafting this agreement.
Which side of the V were they on?
I'm sorry?
Which side of the V were they on? Were they together? When you said, well, the parties were defined as Arch CMAX, blah, 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 blah. Were they all together on one side of the V? You know, against?
The lawsuit.
The lawsuit. Okay, you don't, okay, fine.
I didn't. I
think my
in
colleague
this
said
action
this
and the
one
New
upset.
Jersey action,
I'm sorry?
I didn't follow, I'm sorry.
Okay, when you say the parties were identified in the settlement agreement, right?
Right.
Arch, CMAX, your clients, whatever, they were all together, correct? They weren't,
Correct.
right? So that when you're arguing that this settlement agreement waived or they gave, or Arch gave up their rights against your client. How could that happen if they're all together on the same side of the settlement?
Well, under the GIAs, Arch has the right to settle on behalf of CMAX because Arch, under principles of subrogation, owns all of CMAX's claims.
Right.
So there was no reason for CMAX to even be a party or signatory to that settlement agreement. They would be bound to that settlement agreement. So
I'm not disagreeing with you. You're absolutely right. But then how does that get you to the next level, which is a leap of faith, that means that they waived or relinquished their claims against your client? How do you get there?
In light of the language at 6.6, what does 6.6 mean if it doesn't mean exactly what it says?
there is no reference in 6.6 to the indemnification claims, which is...
So it's meaningless?
It's not meaningless. There are many other rights.
So tell me what it means.
Absolutely. Again, there are 4 separate GIAs covered.
I got that. What does this section, when it said that they don't waive their indemnity agreement rights,
yes,
what does that mean?
It does not state they do not waive their...
It says, okay, so what it says is, surety 6.6, surety makes settlement in good faith. That surety is Arch, right?
Correct.
And then it says surety's rights under indemnity agreements not impaired. And it goes on. CMAX further acknowledges and agrees that nothing in the settlement agreement is intended or shall be construed to waive, limit, alter, amend, or otherwise prejudice Arch's rights, remedies, claims, or defenses under the general indemnity agreements executed by CMAX and others in favor of Arch. It says it like 2 times at least.
Yes.
And the word waiver is in there, by the way, in case you missed it.
I didn't.
Okay.
The thing is, there were multiple bonds issued by Arch.
Yes, you said that, 4 at least.
Yes. So the fact that there is a different course of conduct in this situation, 6.6 preserves those rights with respect to those other bonds, that this situation cannot be used to impair rights going forward because these are general continuing indemnity agreements that secure other
That
bonds.
means your time is up. I'll give you 30 seconds to finish your statement. Go ahead.
May I? And additionally, the intent recital under settled law, it is controlling and it is the lens through which the entire agreement must be interpreted.
Thank you. You have some rebuttal.
Thank you, Your Honor.
So, counsel, you sit over here, and then when he's done, you'll have 2 minutes to rebut.
Brian Gunther, Tori Lentz, Gamal, Gary, and Rittmaster for respondents. Your honors are absolutely correct. Article 6.6 is clear.
Well, counsel says there are 4 different ones. How do we know this one applies to?
Because it says it reserves Arch's rights under the general indemnity agreements, plural, executed by CMAX and others in favor of Arch. There's no ambiguity on this point. Counsel's entire argument here, the indemnitor's entire argument, is trying to get around Article 6.6, but they cannot do so.
Yeah, he's relying on the recital. He keeps going back to the recital, saying that the recital says releasing all claims. And my question, I don't know if you heard my question, was that the way I understood it is that Arch and his clients were on the same side of the V.
That's
right?
absolutely correct,
So
Your
how
Honor.
then was it possible that Arch waives your claims against the same people on your same side? I mean, you're united in interest in that regard, right?
Absolutely correct, Your Honor. There is no way that Arch in any way intended to waive any rights.
And to be clear, and just so that there's avoidance of doubt, you guys put in 6.6.
Absolutely.
Just to be safe.
If there was any shred of ambiguity in this agreement, Article 6.6 was put in there to read out that ambiguity. There is...
Sorry. You can finish your sentence.
I'm okay. Go ahead, Your
Okay.
Honor.
Counsel didn't raise it, but what about the emails?
The emails, if you look at the emails are neither here nor there with regards to anything. This goes to the indemnitor's accord and satisfaction defense.
They don't conclude anything.
They don't
Is that what you're
conclude
saying?
anything.
They
The trial court
leave it
looked at
open?
this. There was no mention in those emails of an indemnity limit of $1.5 million. There was no mention of this lawsuit.
There was no mention of Arch's indemnity claims. There was no mention whatsoever of even a finalized agreement of any nature on any subject.
And it doesn't matter because the contract says you got to get it in writing.
Exactly
If you're going to do
right.
anything like, if it's post settlement agreement, post, new contract, you got to get it in writing. There's no way you can rely on emails.
Right, even if there was an accord and satisfaction reached after the 2007 completion agreement, it must have been in writing. And further to that fact, New York law requires any agreement based on past consideration to be in writing and expressly reference the past consideration. And as the trial court, when they looked at this, they noted there is nothing in these emails that references an indemnity cap at all or the past consideration. If there are no further questions, I rest my briefs.
Thank you. Yes.
With regard to 6.6, under the law, it is required that an indemnification clause, in order to be effective, must expressly state the intent to indemnify, and that is missing from Article 6.6. Arch could have easily put in our indemnification claims with respect to the Whitlock bond remain intact. That was omitted. That is fatal. That is fatal. And going to Your Honor's question, in the intent recital, which was specifically incorporated as an operative provision of the settlement agreement, it is broadly defined. It's all parties. So it does not reference who's on one side of the V, who's on the other side of the V. This was to conclude this subject matter and provide finality. And that's how it's drafted. It's drafted expansively. All parties, they had the ability to use more limiting language, which the drafters chose specifically not to, and all parties were represented by they were all sophisticated parties represented by counsel, and they specifically chose not to use that limiting language. And another point on the emails. With regard to the emails, they were not based on past consideration. This was a promise made prior to the completion agreement, and the negotiations continued post-execution of the completion agreement. And
I'll let you finish your sentence. Go ahead.
Post-execution of the completion agreement, there's no rhyme or reason why, if there was no agreement, which Arch specifically referred to as the overall indemnity repayment plan with respect to the Whitlock bond, why would they be negotiating if there was no agreement being formed? And that, at the very least, raises an issue of fact that should preclude summary judgment at this point.
Thank you. Thank you both.
Thank you, Justice.
MFP 933 Broadway versus 933 Broadway.
Oh. Boy, that feels good. Good afternoon, Your Honors. May it please the Court. John Crossman from Zuckerman, Gore, Brandeis, and Crossman for the appellant, MFP 933 Broadway. This case is entirely about whether or not my client evidenced a repudiation of the contract that they were a party to.
Or whether or not there was an anticipatory breach by your client when they sent the notice that the other side had breached.
You can call it an anticipatory breach, but it's got to amount to a repudiation of the contract in order for the other side to have the ability to simply accept the repudiation and seek damages. And to have a repudiation, the law is perfectly clear. There's no dispute about this. You must be able to show an unqualified and clear expression of my client's intent not to perform under the contract.
Didn't your client, after saying that it was saying that they were not going to close because the other side had breached. It was whatever time on the 7th, it was in the afternoon. And the seller, I'm sorry, said, but wait, the time is not done yet. Our time is not done. And the response wasn't to your client, oh, okay, I'll give you to the end of your time. Oh, maybe we made a mistake. Your client brought the lawsuit, essentially.
There are a few misconceptions in what Your Honor just summarized. I'm going to point them out.
correct
First of
me.
all, my client never, ever said it would not perform. The only thing my client said was, we are going to invoke the termination provision in this contract because the condition has not been satisfied on time.
Yes.
So that is an attempt to perform the contract.
Counsel,
by
I don't
invoking-
understand.
I'm sorry, Your Honor?
We are going to invoke the termination clause in this contract? Doesn't that mean we're done?
As long as the termination is effective, it certainly does mean we're done. But at the same time, in fact, we had been asking this seller for several days prior to this point to explain how they were going to close with multiple important tenants saying they're going into bankruptcy, they're not going to pay their lease. All these problems were coming up.
So how come your client couldn't wait until midnight in order to do that?
My client didn't know that midnight was the time.
Right,
There's a dispute.
but then there was a letter from your adversary that said, oops, there's a mistake here. The operative date really is May 8th and not May 7th.
Yeah, but
So
that's the
why-
problem, is that letter didn't come out until a couple minutes before the end of the next business day, which would have been the end of the time when my client could have terminated the agreement. It was literally, they waited an entire day and then on until almost 5 p.m. to send that letter, which was just before the
Counsel.
closing, with the weekend in
All
between.
right, Counsel, I have a quick question. This boils down to the estoppel certificates that your client said that they were owed under this agreement, correct?
Justice
most
Oing,
part.
I'm having a little trouble understanding.
This has to do with the estoppel certificate, correct?
That's right. The estoppel
So,
certificates
all
had
right,
not
so
been
let-
delivered.
Your time's running out. So my question is let's assume that there was no repudiation, anticipatory breach by you, and the closing date was scheduled for May 11th, 2020, correct?
That's right.
So does the agreement allow the seller up until May 11th, or even at closing, to provide you with the estoppel certificates?
No, it does not. Even they don't say that. Under their reading, they would have had to do it by midnight of the day on which we sent our letter. But I want to make sure that I get this point in before I run out of time, and that is that 2 days before we sent this letter, on May 5th, and this is at record site 72, we wrote and said, we don't understand how you're going to be able to close, how you're going to be able to meet these conditions. And then it says, and this is the important part, my client is not repudiating the agreement. We simply do not understand how you're going to be able to close. And then we go forward at record.
Excuse me, didn't the contract allow for an additional 30-day adjournment of the closing if the estoppel certificates could not be obtained, and by taking the action that you took, you prevented them from availing themselves of that remedy in the, or that provision in the contract?
That is exactly the mistake that the court below made. We did not prevent the seller from doing anything. All the seller had to do was send the note, if they're correct about the time counting, which there's a dispute about what day is which, but if they were correct, I see my time has run out. May I finish my thought?
Yes.
If they were correct about when they had until to do it, then all they had to do was send us the notice adjourning the closing, or send us the estoppel certificate.
But did they have to do that once you said that you were terminating the agreement?
We never said we were terminating the agreement. We said we were invoking the termination provision.
What does that mean? What does that mean? What does that mean? We're invoking the termination provision.
If the condition for termination in the agreement is satisfied, then the agreement terminates. But as was said in the Rapson case, if a termination is sent, a notice of termination is sent a day earlier, a couple days early, as in Rapson, it's a nullity. It means nothing because the condition for which you can terminate hasn't arrived
You
yet.
didn't say that, right? You didn't say, so hurry up and get these things in by midnight.
We thought the time had expired. That's the point. There was an honest, if at best, there was an honest mistake, at best. And we think that our analysis of the counting of time was correct and that the time had expired. But The worst you can say is that my client miscounted the time and under a misimpression of fact said that it was going to invoke the termination clause. That is not an unqualified and clear expression of intent not to perform.
Thank you.
All right, I'm sorry, I'm going
No,
on and on.
it's okay. Thank you.
Good afternoon, Your Honors. Pleasure to be here. Joseph Lee Madelon of Wachtell Misri LLP for the respondent. There could be no more clear anticipatory repudiation of a contract.
Yeah, so I asked the question about, you showing up, assume that there was no repudiation, assume there was, everything was fine. At closing, May 11th, you had that right to show up, you, the seller, had the right to show up at that point to handle the estoppel certificates or do whatever you need to do, right? Because I think the contract, my understanding is that you were allowed to do updates too.
Yes, so actually the way it worked is, in order for a closing to go forward on May 11th, we would have had to have provided the estoppel certificates 2 days before. That's midnight on Thursday. My client wasn't sure. It had one of them and was working on getting the others. So it prepared to extend the contract. And Her Honor is exactly correct. We had 30 days to extend it, specifically to complete the estoppel getting procedure. By their termination, before the closing, that precluded my client from exercising its right, which it clearly intended to do, and get the remaining estoppel certificate.
Did the contract have any specific language that required you to communicate your intention to extend for 30 days at any particular time?
No, only up until the closing. And which
So up until the date of closing, you could have gone to the closing and said, we're going to need 30 more days.
Right, and we would have done that. In fact, we had all of the estoppel certificates the following day. On May 8th, after they terminated the contract, we had them all. But the contract had already been terminated, and a demand...
Well, that's what he's saying. He's saying that they only sent you a letter saying that we are invoking the termination clause, so therefore we're not terminating the...
Judge, that's gobbledygook. Okay, I'm just saying.
I'm just telling you what he said.
And also gobbledygook is that we weren't terminating, we were performing the contract by terminating the contract. That's silly, okay? What they were doing was they said to the escrow agent, give us back the money. They didn't want to close. COVID had started, the market had tanked. They weren't going to put in $24 million to buy this property. They were setting up for a termination a few days before by trying to claim that the estoppel certificates could never have been clean estoppel certificates because of an argument that tenant defaults render them dirty, which is not true.
Well, yeah, because the estoppel certificates doesn't go towards the tenant saying the tenant's
Exactly,
default. It's
only
going
to the
whether or not the seller's in default.
Exactly right. And Justice Knock understood that, rejected that argument, and it's not in the briefs here. They've abandoned it. So what the only argument, really there's two arguments. One is that we've counted the days wrong, and I can assure the court, we all know how to count days. We do it every day, pun intended. But the argument here that there was not an anticipatory repudiation, if my client had said, okay, we want to go to the closing, why don't you show up on Monday, come up with your $24 million, my client would have been very, very, very happy to close. They didn't want to close. They terminated the contract improperly, prematurely, and the consequences are there's liquidated damages, unfortunately only $1 million because my client got hurt much more than $1 million. If there's no further questions, I'll rest on the papers.
Thank you.
The law says that an expression...
Yeah, I forgot about a part that I know you said that you say you intend to exercise the termination clause. I did forget, and the counsel reminded me that you did ask for the escrow agent to return the money to you.
We thought the contract had been terminated.
If you add the two together, that's a termination, don't you think?
No, not at all. They disagreed. All they had to say was, you're mistaken.
But they did say you're mistaken. They did say you're mistaken.
2 days later, after their time to perform had already expired, 2 days later they waited.
But counsel, you tell them you invoke the termination agreement, and then you ask for the money back, and it's on them that they didn't say, wait, don't terminate?
If we're not like some big, giant force that can just unilaterally terminate the agreement. We can invoke the provision in the contract if the conditions are met. We have that right if the conditions are met. So we're dealing with two things. If you accept their counting, it's a mistake as to fact, as to whether or not the time had expired, so it can't be an unqualified and clear intent not to perform. If we could have had a conversation about the timing, and they could have said, no, this is how you count it, and we could have agreed with them, that would have shown intent to perform. And secondly, if we wrote to them and said we are not repudiating the contract, and we wrote to them 2 days before this letter and said, we are not repudiating, and then in the letter that we actually sent the repudiation, we specifically said our client's position in our May 5th letter, the one where we said we're not repudiating, remains effective.
But counsel, when you put this within the backdrop of the fact that one tenant indicated that it would be filing for bankruptcy with a specific intent to reject their lease, their tenant lease, and another tenant had ceased paying rent. When you put that in context, it does seem like your client really and truly said what it meant, which is, I don't want a part of this deal anymore. There's two major tenants out the window, and I don't have my certificates. So I'm invoking the termination provision. Thankfully, I'm off the hook.
Well, we had no other remedy than a termination provision. The contract says if you don't get the certificates on time, your only remedy is to terminate. So what else could we possibly do? So if we're incorrect about the timing, then the only proper response is that in order for the seller to be
Counsel,
able...
but you keep on ignoring the fact that they had the right to take advantage of the 30-day extension.
Yeah, but they could have done that. We would have been perfectly in agreement if we understood that they had not yet, the timing had not yet expired.
I don't see how that's on them, though.
Well, that's what the contract provides. That's the sequence. My time is up.
It is, and I've been very gracious.
This time I'm clear on it.
Thank you and good night. Thank you to both of you. Martinez versus Kingston 541.
May it please the court, Dana Catanzaro on behalf of defendant, appellant, respondent, Midwood Living. Good afternoon, Your Honors.
Good afternoon.
I'd like to focus preliminarily on the contractual indemnification claim. It is our position that the lower court erred in failing to grant contractual indemnification to Midwood Living. This is an extremely straightforward case where the contract between the owner, my client, Midwood Living, and the general contractor, defendant, respondent, appellant, Busa Builders, required Busa to indemnify the owner, Midwood Living, for any bodily injury accidents such as plaintiffs here.
Did Midwood argue anything below about the negligence of Busa or DHM?
It was implied in the papers that Midwood submitted on the underlying motions. And
when you say implied, meaning it wasn't stated below?
It was argued that the accident arose out of, if summary judgment on 240 was granted, and if the court found a finding of liability under 240, which it did, that the accident arose out of either plaintiff's actions triggering sole proximate cause or recalcitrant worker defenses, or it arose out of the work of plaintiff's employer.
Well, you're asking a lot for the court to try to get all that implication when the court says right here, notably, Midwood focuses solely on the arising out of language in the contract indemnification, and you didn't, and it's caused by, but there was no discussion about the negligence of Busa or of his subcontractors. Now, you're asking us now to say, if the Supreme Court below found that and you saw that, you should have moved to re-argue and say, hey, you know what? I think you overlooked something. You can't do it, but I don't know, but for me, implications are kind of hard.
I understand that, Your Honor, and in reviewing the papers in preparation for today, I did note that the attorney who wrote the underlying papers was not as clear as I would have liked her to have been.
That's not on us. That's well, no,
Absolutely,
on me. That's
Your
on
Honor,
you.
but I think the record that was submitted to the court and the underlying
But
papers.
you're asking us to reverse and grant you summary judgment when you didn't even give the motion court, the Supreme Court, the opportunity to even explore those issues, right? I mean, that's not fair, I don't think.
I agree, Your Honor. I do think there was a significant, whether it was written as well as it could have been in the papers or not, I do think all of the facts were outlined in our motion papers, that this arose out of the negligence of Boose's contractor, D. Heavy, who was plaintiff's employer. And as the clear was implicit in its finding that there was no negligence on the part of my client.
Well, maybe your better argument is, do you think there's a 240 liability at all? Because if you knock out 240, then this all is moot.
I
right?
don't think there is 240 for the reasons set forth in our papers. I think there is significant evidence in the record to establish a sole proximate cause.
But essentially, you're saying you started with your strongest argument.
I'm starting with my strongest argument. I don't want to waste the court's time, Your Honor.
Okay.
Thank you for that.
Thank you.
All right. If there are no further questions, I'll rest on my papers.
Good afternoon, Your Honors. Andrew Showers for defendant, respondent appellant, Busa Builders, LLC. We respectfully submit that the Honorable Francis Kahn's order.
So should we reverse and grant summary judgment to the appellant against you for contractual indemnification?
No, Your Honor. I agree with your insight that they
Well, I don't know about insight. It's just like,
well,
kind of read the record. There's nothing there.
Correct. Correct. It wasn't argued in the court below. My client was not negligent. In the court below, Midwood adopted our arguments that the plaintiff himself was the sole proximate cause of the accident. We maintained those arguments on appeal. The plaintiff changed his testimony at least 3 different times with respect to the safety devices that were provided to him. He was wearing his harness at the time of this incident.
Where was he supposed to tie off?
Your Honor, he testified that he had a metal safety cable with a wheel on it.
Where was he supposed to tie off?
Previously, he had tied himself off to the safety cable. He had tied himself.
Right, but this was an instance.
We didn't get that far because plaintiff's counsel blocked my questions.
Well, this was
That's
an
in the
instance
record.
where he was moving back and forth. There might have been tie-offs, but not one where he was moving back and forth to get tools the entire time. There was only one where he would have had to have maintained this position within 2 feet.
Yes, but he testified 3 different ways. He testified that he had a metal beam that he could tie off to. He testified that he had a long cable that he could testify to that had a wheel on it. He testified also that it was rolled up and he
You know,
saw
at best, what you're saying is something that would be contributory negligence, which is not a defense to 241. This is a person who was wearing the jacket that would allow for the hooks, and he had hooked on at one other time. But now he was in a different role. He was asked to go down the basement, put a ladder down, you know, so that he go down the basement. He was told that he should walk on the joists. There wasn't plywood on all of the joists. He did walk on the joists when there was no plywood. The joist broke. He went down. He was actually in the process of moving there from another area. So this is not, where was he supposed to tie off and be able to perform the functions that he was directed to?
tie off overhead on the steel beams, tie off to the safety cable, tell his employer, wait a minute, I need to reposition my safety
As I
cable.
said, why isn't that contributory negligence, if at best?
Your Honor, if the worker takes the most dangerous method, that's not too...
No, the most dangerous method was telling him to go walk on those joists.
No one told him to do that. Not one single person told him to do that.
Well, that's not what's in the record.
I
think Judge Moulton has a question.
Sure.
No, I was going to make the same statement that you just made, just from...
His employer did not tell him to walk on the joist.
Azulay is one of the employers, is one of his directors, supervisors.
That's the owner of the third-party
Azulay
defense.
instructed him to walk on the joist.
He was not present.
Kamas, well,
His
he
employer-
didn't have to tell him that day. It wasn't his first day on the job, was it? He gave him instructions on what to do. He told him to walk on the joist. Also, Kamas told him to walk on the joist to access the ladder to the basement.
And also the staircase to the basement was, the door was locked, so they had to use the ladder to the basement. I mean, would you disagree with that?
I disagree in the sense that I don't think plaintiff ever tried to access the staircase. He just said it was locked. That's my recollection.
Was there
It's
any?
even, yeah.
Okay, good.
They also said that the door to the basement was blocked because there was material being kept in that area that was blocking the ability to open that form of egress and ingress.
Even the owner of the building said that.
I didn't lead with the stairway argument. I think the
Well,
stronger
then
argument...
maybe you shouldn't make the argument you just made that he didn't open the door. What, was he supposed to get the whole crew to come and, hey, my director, supervisor told me I need to get this ladder down there to try to do whatever I'm supposed to do and walk on the joist to get there, but I think I better go through the door that has all of this stuff in front of it and is locked. Can you go see if you can help me move all this stuff and get the key? What? Make a realistic argument then with regard to that.
I think the realistic argument is that he had all the safety devices that were available to him and he didn't use them. That's our realistic argument.
Wasn't the cable lying on the floor, the tie-off cable, wasn't it uninstalled and lying on the floor?
That was one of the arguments that he made, but he also said that it had been installed and had a wheel on it that could move around. And then
Okay.
when I asked his attorney, did you tell your employer that you would need to step off of the plywood in order to access the ladder, his attorney said, don't answer that question.
Okay, you have 1 minute rebuttal.
Thank you, Your Honors.
Please the court, Alex Waller for the plaintiff respondent. Your Honors, if I may, I'd like
Did you
to
stop him from answering that question, or somebody else who was there? Stop him from answering that question?
The plaintiff was never stopped from answering any questions. I was going to say, if I may, I'd like to rest on my brief. There's nothing that I could add that's not in my brief. Your Honors have, by your questions, have shown your familiarity with the arguments for and against, mostly for 240 sub 1 summary judgment. If you want me to.
Was there any place to tie off?
No. And I explained why in my brief for several reasons.
Yeah, because if he tied off, he couldn't get to what he had to do, right? I mean, that's the problem. It's like, it's not his fault. I mean, he tried, but he can't.
There was no way to tie off for 4 or 5 reasons, and each one was testified to. The plaintiff wasn't prevented from testifying to anything. His credibility wasn't an issue. When counsel says that he was changing his testimony, he was referring to different parts of the site that had different reasons. You could either tie off to a beam, which wasn't in place above him when he was hurt, or you couldn't. And it's if you read, and you did obviously read the testimony, his credibility is not an issue. He was not a recalcitrant worker. He was not the sole proximate cause.
I mean, the way I look at it, if counsel is arguing that you're preventing his client from answering questions, I mean, the remedy would be to go to Supreme Court and tell the judge, or ask the judge to direct your client to answer the questions.
Of course.
I didn't see that in the record unless I missed it.
The defendant's counsel was not a neophyte. They knew what they were doing. If the plaintiff was not answering questions, right, call the court, get them to answer the question.
Yeah.
Thank you, Your Honors.
Thank you.
I'd just like to make 2 points in rebuttal. The first is with respect to the contractual indemnification claim. And as discussed before, the decision of Justice Kahn found that Midwood was not negligent, Busa was not negligent, and they granted 240 on summary judgment. If the 240 is permitted to stand, then in the sake of judicial economy, the court should reverse the lower court's decision and grant summary judgment to Midwood Living. There is no reason for a jury to determine the issue of whether or not the contractual indemnification clause here was triggered, as the record is extremely clear. And while the motion papers may not have been as clear, the record in the underlying motion that is part of this appeal is extremely clear as to the contractual indemnification here being triggered. I would just like to also add.
Am I right that the thing that happened that caused this accident was the breaking of a joist.
That's correct, Your Honor.
That doesn't normally happen when a joist and the building is in proper condition. So on what basis would the defendants, BUSA or a subcontractor, be responsible for a joist that is so defective that the weight of one man would break it?
May I respond?
Yes.
Preliminarily, Midwood testified that they conducted an inspection of the property prior to anyone performing work. They also retained BUSA to be responsible.
Was there a floor over those joists when they did that inspection?
That is not clear from the record,
Because you
Your
can't
Honor.
see a joist unless the floor is up. So if you do an inspection before there's been any gutting of the property, you're not going to see what the joist conditions are like, right?
Absolutely. However, the joists were not there for people to walk on. This was the integral part of the work. Was
Except when you
removing the
take off the floor, then that's the only thing you have to walk on.
Right, except in this case, and this is why there is sufficient facts in the record that a jury could find that plaintiff was the sole proximate cause of the accident, is that plaintiff did have available safety
Look,
devices.
you know what, your contractual indemnification claim, it's not that you lost it. I mean, you're jointly and severally liable under vicarious liability, so that at the end of the day, when this is all concluded after, whatever happens after the damage phase of this, if we agree, right, you know, that your contractual indemnification claim is there. You still have it.
Absolutely, Your Honor. I just don't think a jury needs to, when there's clearly just a matter of law here that has been met from the record.
Thank you.
Thank you, Your Honors.
I agree, Your Honor, that a wooden joist should not break in the normal course of events. Therefore, the jury could find Midwood solely responsible for this accident. And
So you don't think for convenience sake we should avoid having to put the jury through this task?
I think that there is a question of fact, and Midwood was properly denied contractual indemnity and the other relief that they sought by the lower court. With respect to the question that wasn't answered, it's on 433 of the record. I asked, sir, before you left the plywood area on the date of the accident, did you tell Wilson that you needed a place to tie off your safety harness? Mr. Walcott, the attorney for the plaintiff, objection to the form. Question, that you were wearing. Mr. Walcott, again, objection to the form, don't answer. Mark it for a ruling.
Did you get a ruling?
Yeah, did you even go to the judge to ask for a ruling?
Or attempt to ask the question in proper form?
Well,
I don't know.
Your Honors, later that day, we did call Justice Bluth, I believe it was.
And?
I don't, there's a large amount of colloquy. I don't know whether that specific topic was raised, but.
So then that would be on you, right?
Yeah.
Or whoever was there at the time.
Respectfully, there was no privilege asserted, so my understanding under the rules is that you can't direct a witness not to answer a
Right.
question.
Except this was to form. There was a reason, it was an objection. So in that instance, you can. You didn't correct it to their satisfaction. That would be the basis to go to the court. Thank you, thank you.
Thank you, Your Honor.
NYC organization versus Campion?
I feel the same way. Just in case.
Yes, you may begin.
May it please the court, Richard Deering for the city. The lower court misconstrued Ad Code 12-126B1 in two different ways. The first was misunderstanding the nature and the scope of the obligation imposed by the statute. The second was misconstruing the statutory cap in the local law.
So counsel, looking at the section, I'm looking at the definition of health insurance coverage, and the words that reference health and hospitalization insurance contracts is plural. It's not singular. There is nothing here that says that the city will pay the entire cost of health care coverage for city employees, city retirees, and their dependents with respect to one health care contract only. Therefore, if there's no modification of 12-126, how can we do that?
Well, a few points. I'll go first to the contracts point, that plural word. I think you have to understand that in the context at the time that law was adopted. And I'll give you two key facts about it. First is,
But I am. I mean, there was a threshold set in 1967 that said that the city would pay up to whatever the HIP Blue Cross threshold was, right? And then there was an amendment or a change in 1984 that threshold would be set by HIP/HMO. Good, not a problem. I mean, that's really not an issue, right?
well, I think the key there is
the issue is statutory construction.
Sure.
And doesn't the administrative code say what it says, as in plural?
Oh, it certainly says that, but the point I want to make is it was common, it was actually all the city plans at the time were offered by multiple companies under multiple contracts. That was true of all three plans. And the plan that so meaning when they used that word plural, it was fully consistent with the idea of a single plan. Justice Frank, I think, correctly understood that definition refers to a plan. He said that on record at 9. But the local law originally referred to HIP/Blue Cross, 2 companies, 2 contracts. That was one plan. The other 2 plans that were offered at that time were GHI/Blue Cross, 2 companies, 2 contracts. The final was Blue Cross/Blue Shield/Major Medical, 3 companies, multiple contracts. So I don't think there's any inference that can be drawn from the plural word. And I think the more important statutory construction point is that the petitioner's reading of the healthcare coverage definition to encompass all plans just doesn't make sense of B1 from a syntactical standpoint.
This has always been the case. I mean, for years, if you look at the legislative history, if you look at the history of this, the way this has gone for years, it's always been that there are policies and that the amount is paid up to that HIP HMO threshold. So why now is it all of a sudden it goes from multiple and A, which could have been substituted for the word one, which would have been clearly what anybody would have put in. A is now meaning just one policy. It doesn't even read intelligently.
I don't even think, first of all, we're happy to accept the HIP HMO threshold. That's our second argument.
Yeah, that's $7. How did that, am I correct? That
Well,
it's $7 right now? That's another question. How did it go from 100 whatever to $7?
But for years, I
can
can speak to that point. I think what it shows is that is the value of competition created by this bidding process itself, that we've been overcharged for years for the HIP HMO, Medicare HMO, and that it is just this step. This is why the Municipal Labor Committee fully supports this. It is just this kind of step that was needed to control spiraling healthcare costs.
But nobody's arguing cost here, right? Nobody's saying that the city has to do a certain thing other than what the administrative code says.
Well, I think that's right, but I do think the petitioner's construction of the cap would impose radical new obligations to the city that it has never borne at any point in history.
Let me ask you this question. I'm sitting here listening to the arguments and reading the papers here. Why don't you just eliminate all the options and have only one plan?
I think the city may well have to do that, and I think that's
that would have been the simplest thing to do.
And I think that may well be where it has to go, but I also think that just underscores an absurdity to Justice Frank's understanding of the statute and shows why our reading must be right.
Because if you have all it's like my colleague says, you've had all these multiple plans in place in the past, and now all of a sudden you're changing the payout, or at least you're changing the contribution method. I mean, the simplest thing is if you didn't want to have any of these problems, just eliminate all the choices, and you have only one choice, and that's the end of it.
I think it's a possible route, but I also think that underscores the absurdity of the reading. Okay. I think 2 key points, though, I want to make, though. One is on the plans plural concept, and the other is on the cap, which I really think is also very important. and takes a little bit of unpacking. The prior Board of Estimates resolutions that the petitioners rely on did something very specific that the local law did not do. And what they said was, a choice of plans will be given consisting of the following 3 plans. They did precisely that. They also had a separate provision about payment. In the local law, what do we get when the city council sits down to codify the minimum obligation? They did not codify that first piece of those Board of Estimate resolutions. They did not codify the choice of plans language. They did not go further and specify what that choice would be. And frankly, if without that kind of specification, we have a totally abstract and formless inquiry. What they instead did was enact a minimum obligation that we must provide one premium-free plan, at least a premium-free plan, and that is precisely what we're doing. And if I could just go to the statutory cap, because I think...
If you could quickly go, because I've already given you extra time. I know we asked a lot of questions, but that's taken up by the time,
Right.
so quickly.
Petitioners are proposing a $776 cap from a plan that is for people who aren't eligible for Medicaid.
Okay, there's a lot in between $700 and $7, isn't there?
There is a lot, and what I will say is Medicare HMO has been less than senior care consistently over time, regardless of this $750 drop. There have been fluctuations in HIP HMO pricing over time, including significant drops and significant rises, but it has been less than senior care for quite some time, and the HIP Medicare HMO, after all, the local law says HIP HMO, and that is a HIP HMO, and it's for Medicare-eligible individuals. And the proposal of petitioners to instead, I think there's just 2 points. I understand the point.
Okay, I'm going to have to, if you can't wrap it up now.
I can wrap it up very quickly. It should not, the comparison should not be based on a plan that these petitioners are not eligible for, that is actuarially irrelevant to their costs, and that is at least 4 or more times more expensive than a Medicare-based plan. And secondly, we have never paid the 776 number, and that would include, if they were right, that would require us to fund a lot of super deluxe Medicare plans that the city has never paid for, and no one has ever objected, including the petitioners in this case, have never objected and said we had a legal obligation to pay for those plans.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Jacob Gardner on behalf of respondents, the retirees. The retirees spent their lives serving this city.
How do they figure out the base, the threshold, that amount? You know, they're saying that they have to pay 100% of whatever. How do you get to that figure?
Sure. So first of all, a little history here. The first statutory cap plan was the HIP Blue Cross 21-day plan. That plan was selected because it was the most expensive plan at the time. That's why you have that statement of legislative intent that says very clearly this bill would provide that the city of New York pay for the entire cost of any health insurance plan. And then in 1984, the HIP Blue Cross 21-day plan became defunct. It was replaced by the most expensive plan at that time, the HIP HMO plan. So always the intent was for all plans to be covered. And what happened is in 1967, Mayor Lindsay wanted some sort of concrete cap. And so what they did, the city council did was—
Because the most expensive plan at the time was going to bankrupt the city, probably. But in any case, there must be some reason why the most expensive plan, they had to look it over. Okay, go back to Mayor Lindsay.
Sure. So Mayor Lindsay just wanted a cap. And so what the city council did was they said, okay, here's the cap. It's the most expensive plan. So that way, the Resolution 292, which had been in existence that required the city to pay for all of the plans at the time, would just continue in effect. And in fact, if you look at record site 1327, it says explicitly that Resolution 292 is codified in this new legislation. So the intent was very specific in that quote I just read, and also in the fact that they were just importing Resolution 292 and codifying it into a statute. So the city has always paid up to the cost of HIP HMO. The city is arguing that the actual cap is this other plan, HIP VIP, but the city has always paid beyond HIP VIP. The city admits that the HIP VIP plan is less expensive than senior care, and they've always paid for senior care. Well, that statutory cap is a ceiling. It says that the city's payment shall not exceed the HIP.
And you arrive at the statutory cap by taking the most expensive plan out there?
Excuse me? Sorry?
You arrive at the statutory cap by taking the most expensive plan out there? I mean, that's what I'm trying to get at, right?
I mean, the cap is the HIP HMO plan. It's never been the HIP VIP.
Whatever they're charging, that's the cap.
That's correct.
Is that the $770-something number?
That's correct. And by the way, I should note 2 factual updates for this court. One is on September 10th, the city of the actuary office produced a report, an actuary report, that says the cost of different plans. It definitively said that the cost of HIP VIP is not $7.50. It's about $190. So that is just, it has never been $7.50 before, it is not now. So that is just an outright lie. My second point is, if the city wants to withdraw funding for retirees' existing health insurance, it can do that by just amending the statute, and it did. I mean, it is attempting to do that now. Just a few weeks ago, it proposed an amendment to the statute that would allow it to do what it's seeking to do now and what it claims it can currently do. This court should allow that statutory amendment process to proceed and not by the city's...
That goes to my point about how if the city, to make it simple, just have one plan. You don't have to have all these multiple plans, right?
Well, that is not the issue. The question of whether they can do that is not before this court.
Right.
But the city has a number of options available to it without violating this statute. This court should not allow the city to violate the statute. It should force the city to take the political accountability route and go through an amendment or do something rather than just try through this appeal to bend the words, the clear words of the statute and the clear words of legislative intent to get its preferred outcome. And we will, of course, try to fight that statutory amendment, but I think it's important for this court to know that that process is happening now and should be allowed to play out.
Thank you.
Thank you very much.
I'd like to talk about the cap, because I think this is a clear mistake by the petitioners, or, I mean, mistake is generous. The city has, I didn't hear a response to the idea that the city has never paid for the deluxe plans. Didn't hear a response to that. I didn't hear a response to the fact that there's never been a legal objection to that fact. There are many plans, there are Medicare plans that cost a lot of money, that give very, very high coverage. We have not paid for those plans historically, and no one has said a peep about it. I hear no response to it.
The problem I'm having with this argument is that you have city workers who, during their employment, made options about their health care. And not all people are in the same position. So you have some people who perhaps have overcome cancer and various other kind of diseases and conditions that they don't want an HMO plan. They need to have a plan that allows them to pick their own doctor. And so this attempt to kind of go around what people have earned is really problematic to me without it going before the city council.
Can I just, the Medicare Advantage plan is not a HMO plan, just to be clear. The HIP HMO plan that's referenced in the cap is an HMO plan, but the Medicare Advantage
So unlike my colleague here, I am not for a one plan fits all, because one plan does not fit all.
the city doesn't disagree with that. We think the better route for retirees and employees and others would be for there to be multiple plans offered, and to recognize what's clear about Ad Code 12-126 is that the premium pre-guarantee attaches only to one plan. If I could just talk about the cap, because I think this...
Wait, so only one plan. So that would mean only one plan is covered up to the amount, and then all the others are available, but you got to pay.
That's right. You have an option to decline that plan.
Pay the premium, so that's not offering a plan.
It is offering a plan.
No, it isn't. It's not offering multiple plans.
Agreed. It's not offering, it is not guaranteeing multiple plans.
My question to you is, why should we usurp the role of the city council and amend this legislation judicially?
I'm not asking you to amend it, I'm just asking you to construe it. And I think that, and if I could just talk about the cap, because I do think this is really important. The language referenced in the statute
Your time is up. That's happened before. I'm going to give you a few minutes to...
All right, I appreciate it, Your Honor. This is a $600 million annual issue.
Yes, I understand. Everybody here today has had a very important issue.
No question.
Okay.
The local law refers to HIP HMO. There are two different HIP HMOs, as there are for many plans. There are two versions, one for Medicare eligible, one for non-Medicare eligible. The costs are radically different, 4 to 1 or more. And it is totally consistent with the statutory language to understand that that reference to HIP HMO in the case of Medicare-eligible individuals refers to the HIP Medicare HMO. And I'm glad that the petitioners mentioned the report of the actuary, the city actuary. Every single year, the city actuary reports on the city's plans, and the actuary recognizes that HIP HMO has two versions, a Medicare version and a non-Medicare version. And I want to just draw the court's attention, if I can, briefly to a four-word phrase that comes right after HIP HMO in the local law, which is on a category basis. And what that shows you is that the city council understood that they wanted this statutory cap not to be the most expensive plan that you could find, to have a cap that was meaningless, but for it to be an apples-to-apples comparison, and apples to apples.
But the one you have
HMO
now is
plan.
$7. Am I correct? Am I mistaken about that?
That was for this past
Is that
plan year.
what it
We don't
is?
know what the cost will be for the next plan
Is
year.
it $7?
For this plan year, that was the price, but we don't know what it will be for next plan year. And I will say petitioners have suggested, without any basis, that the reason that price was dropped was because the provider was also involved in the former Medicare Advantage plan. I'm just going to point out, they're not involved in the Medicare Advantage plan anymore. And so we'll see if that price holds or if it doesn't. But the fundamental reality is that a cap for Medicare-eligible individuals should not be based on the exorbitantly more expensive plans for non-Medicare-eligible individuals. Fundamentally unfair and improper.
Thank
Never
you.
has happened.
Thank you. Thank you both.